So, ladies and gentlemen, welcome to another discussion. That today I'll be talking with you at the essential issue, which now is the news that is there is a issue between the judiciary and the executive. So, the power of judiciary and the power of executive now is being controversial due to some reasons. A couple of weeks ago, we have the news that the Supreme Court gave its verdict on that in the case of Governor of Tamil Nadu versus State of Tamil Nadu, that under Article 200 and Article 201, that the governor will have to take his decisions minimum within 1 month and maximum within 3 months. These were the verdicts upheld by the Supreme Court in the last couple of weeks. But now the president, who is the republic head of this state of India, she asked 14 questions to the Supreme Court. That is it the power of the Supreme Court, the judiciary, will decide that how and in which day period of time the governor or the president will take the decision over any bill passed by any legislature, or you can say the parliament. These are the questions which are being asked by the president of India to the Supreme Court. But before this issue, let me ensure at the outset that Supreme Court is considered as the guardian of the constitutions. When there is a question over the substantial law of the land, it is the duty of the Supreme Court that to resolve, and the Supreme Court will give or urges some order to the executive and the legislature to normalize all the situations. In the last 5 years, in Tamil Nadu and Kerala, there were the issues. There were some bills were passed by their concerned legislature, but the governor of these concerned states, Tamil Nadu and Kerala, they took more than 3 years to give their assent to the bill, or the governors of these states were remained silent over the decisions of these bills. Here, let me point it out that as per the Article 200 and 201, there is the provision that the governor can use its absolute veto. Governor can use its suspensive veto over these bills. The governor may give his assent to the bill. The governor may not give his assent to the bill. The governor may withhold the bill. The governor may reserve the bill for the considerations of the Supreme Court. And the governor may, as per the suspensive veto, the governor may return the bill to the concerned council minister or the legislature to reconsider. And when the state legislature or the council of ministers, with or without any amendment to the bill, reconsidered and again resent to the president of India or the governor, so far as your Article 200 and 201 is concerned, then it is obligatory to the governor or the president, to the governor, not to the president, to give his assent, to give their assent. But within the last 5 years, in the cases of Tamil Nadu and Kerala, these were the issues where the governors were silent. The governor didn't take a single decision over a lot of bills, more than 100 and 200 bills that have been passed by the state legislature in Tamil Nadu and Kerala. But the governor of these states remained silent over the decisions of these bills. And when such types of situations of deadlock arised, the concerned state government went to the Supreme Court and seeks for the readdressal systems of these types of ambiguity, so far as your executive and your nominal executive and the real executive is concerned. But the Supreme Court gave the verdict in 2019 in the state of Kerala, Governor of Kerala and the state of Kerala. The Supreme Court apex could upheld that the governor or the president will not use their pocket veto so far as the consent to the bill is concerned. But in spite of these verdictions order given by the Supreme Court, these non-BJP led governments or governors, those who are in these states, they are used to practice the same normal positions of the governor so far as to keep their consent to so far as to keep the giving assent to the bill is concerned. So this create a deadlock situations in the proper executions of executive so far as the executive and the legislature responsible and cooperation is concerned. But now the it is very you can say the very interesting thing is that the executive head of the state, or you can say the executive head of this country, Supreme Court, asking question to the Supreme Court that is it the power of the Supreme Court that the Supreme Court will decide when and how the governor will take the decisions over a bill? Is, and like these 14 questions have been asked by the honorable president to the Supreme Court, that if the Supreme Court is considered as the guardian of the constitutions, so when there is a question of substantial law, when there is a not the proper functions of the constitutional provision so far as the executive legislative function is concerned, so there is the duty of the Supreme Court. They should interfere, they should review these cases, the matters, and they should give the order to this executive to do their duties. But in spite of these things, now there is a tussle between the judiciary and executive again began, and it is not good for the real democratic systems. The governor, those who are in these non-BJP led states, they are in some extent apart from the discussion. If you go to the beyond this political scenario, because in some extent these are the political ill will, and due to their non-BJP led states, so you can say there is sometimes some types of disagreement between the ideologies of two different kinds of political party. The governor, although we know that the governor will not have, governor will not have any link with any political party, but we know the realistic scenario of the governors of different kinds of states so far as concerned, because these governors they are not free from some types of political influence. So to some extent there is the practice of ill political wills. There is a propaganda to perpetuate some constant political party ideologies. These are the hidden intent for such types of quarrel between the judiciary as well as your executive is concerned. So far your Tamil Nadu, Kerala is concerned, this case has been arisen due to in the state of Tamil Nadu, in the cases of Tamil disagreement in the executive and the governor in state of Tamil Nadu and the Kerala. But last before the 2 weeks of our discussion, that the Supreme Court given a clear-cut verdict on that the governor or the president has to, there is a minimum period is 1 month and a maximum period is 3 months. So it is the question which are being asked by the president of this India. So we don't think that these are the the most important thing I must mention here. The verdicts given by the Supreme Court, the bench was consisted of only two members of judges. But as per the Article 145, if there is a question of if there is a serious matter of questions regarding the constitutional matter, the constitutional benches must be consisted of at least 5 judges. This was one question the President of India may ask to the Supreme Court back as per the constitution there must be five benches, in that bench to review or to give his predictions over any constitutional matter. We need five members of judges to consist of a bench. This was one thing the Supreme Court has did. Then we will hope that this quarrel of executive and judiciary will be normalized, and the executive will accept their you can say executive will accept their what the fault, or they should be refrain from such types of illegal political practices. And I don't think that Supreme Court has done something, you can say the judicial activism in being practiced by the Supreme Court. There is no sign of pro judicial activities by the Supreme Court. As the Supreme Court is the guardian of this constitution, so it is very normal to give order to the executive that you should refrain from political evil and you should do what is as per the constitutional provision. With this, I am ending this topic. Hope this quarrel between judiciary and executive will be normalized very soon.